we will start. It's time to start. So thank you for joining us. Thank you for being with us. In this second session, we are having on Canon Law with Sister Sharon A.Euart from the States. The first session, we had it in October on general items of Canon Law, and then many questions were coming up. And so we thought it would be very important to follow up on that first session. And so today we have again Sister Sharon with us to look at specific themes on Canon Law. She will lead us into that, in those themes, and I will put on the chat in a bit the PowerPoints in different languages so that you can follow in your own language. We also have the translators with us, which we are very grateful to. And I'd like to introduce Sister Sharon for you, for the ones who remember and for the ones who don't remember. Sister Sharon A.Euart, she is a Sister of Mercy of the Americas, and she is the Executive Director of the RECRE, which is the Resource Center for Religious Institutes in Silver Spring in the United States. She has various degrees and formation in Canon Law, and she received the last graduation from the Catholic University of America. She has a lot of experience. I could go through all the experience she has. She has been working with bishops, Episcopal conferences, conferences of religious congregations, and she's a consultant of Canon Law for all those realities in the church. And is in that, with those competencies that she's with us today, as she presents on Canon Law and religious life issues. That's her speciality. So Sharon, thank you so much for being with us again from the other side of the Atlantic. It's early hours for you this morning. So over to you. You lead us in how we will proceed today, the times, and I'll be here accompanying you. Thank you so much. Thank you so much.
Thank you, Paula. I am really delighted to be with you again. I feel like I've seen many of you before and that I have this kind of nice, friendly relationship with you. What I hope to do today is we have 4 topics. And after each of the topics, take just a minute break to move our mind to another issue. And then after the second topic, we'll take maybe a 5-minute break. And then hopefully there will be some questions, some time for questions at the end. Right now, I think I should share my screen, and the slides will move forward, and you will also have them in your language from Paula. Can you all see the screen?
We can. It's lovely. Thank you.
Good. Okay. Thank you very much. I really am happy to be here because I find this experience of the international reality of religious life very, very meaningful. And I'm very honored and privileged to be able to share this time with you. Just 1 second, I have to put my the slide changer in. Got that? Yes, these are the 4 topics that I hope to cover today. The canonical authority of superiors general and provincials, their roles and responsibilities. Secondly, absence from a house, the institute and the required permissions. Third, the personal patrimony of individual members, including policies and procedures. And fourth, the relationship and responsibilities between bishops and religious. The first topic is the canonical authority of superiors general and provincials. In this topic, I'd like to consider the general role of the superior as reflected in the code, and then we will identify the canonical responsibilities or functions that are reserved to the supreme moderator according to the canons which identify the supreme moderator as the competent authority. The supreme moderator, as you know, is the highest superior, exercising authority over the entire institute, its provinces, regions, or subdivisions, its houses and members. But in many institutes, the highest superior, the supreme moderator, is referred to by various titles such as superior general, general superior, president, or in the spirit of the institute's traditions, titles such as minister general, prioress general, master general, and so forth. I will try to use superior general for this presentation. We will also look at the canonical responsibilities and functions assigned in the canons to competent superior, major superior, or competent authority in the institute. Also, the delegation of canonical authority and the principles that guide delegation. Sounds like a lot, but we will get through it. First, the role of the superior. Canon law identifies a relatively small number of responsibilities that are reserved to the superior general. The foundational canons on superiors, canons 618 and 619, are derived from the teaching of Vatican II, particularly in Perfecte Caritatis 6 and 14. It is important to keep in mind the canonical role of the superior described in these canons, as they include important exhortations on what authority is. They reflect the teaching that all authority comes from God through church structures and is exercised by canonical leadership in a spirit of service. The role of the superior is largely one of a unifier, unity and charity, to foster the life of the institute and to advance its mission in the church. The responsibilities for a superior are broader than the legal and prescriptive requirements attached to the office of superior general and provincial. They provide a theological reflection on the ministry of service. I'd like to just read these canons to you because they really are a beautiful guide and reflection on the role of authority. Superiors are to exercise their power received from God through the ministry of the church in a spirit of service. Therefore, docile to the will of God in fulfilling their function, they are to govern their subjects as sons or daughters of God, and promoting the voluntary obedience of their subjects with reverence for the human person. They are to listen to them willingly and foster their common endeavor for the good of the institute and the church, but without prejudice to the authority of superiors to decide and prescribe what must be done. Canon 619 goes on to say that superiors are to devote themselves diligently to their office, and together with the members entrusted to them, are to strive to build a community of brothers or sisters in Christ, in which God is sought and loved above all things. Therefore, they are to nourish the members regularly with the food of the Word of God, and are to draw them to the celebration of the sacred liturgy. They are to be an example to them in cultivating virtues and in the observance of the laws and traditions of their own institute. They are to meet the personal needs of members appropriately, solicitously to care for and visit the sick, to correct the reckless, to console the faint of heart, and be patient toward all. These canons are important exhortations for all superiors. They provide a context for the canonical responsibilities and the functions of the highest authority in the Institute. Now, the following slides reflect the responsibilities and functions of the Superior General that should be included in the constitutions. The language in the parentheses and in the blue is the language used in the canon. And we'll explain this as I go through them. I'm going to try to go quickly because there are many of these. Canon 668.4, renunciation of patrimony. And in the blue, it says, this should be in your proper law and requires the permission of the Supreme Moderator. That's what the canon says. 647, designation of the novitiate is done by the Supreme Moderator with the consent of the council. The next is departure from the institute prior to the expiration of temporary vows. The Supreme Moderator with the consent of the council. Transfer from one province of the institute to another, or transfer from another religious institute, the Supreme Moderator with the consent of the council. Decision to readmit a former member, Supreme Moderator and consent of council. Indult of exclaustration, again, Supreme Moderator with consent of council. Now, departure of a perpetually professed member, according to the norm of law, is Supreme Moderator, here's a different language, with the permission of the council. With the opinion of the council, which does not mean their consent. It means their consultation. The next one is Canon 85, which is in the Canons on General Norms, to provide for a lacuna in the law. This would mean there's something in your law, your constitution, that is missing. And there are certain things that can be determined by the Supreme Moderator or as determined in your constitutions. And then the dismissal of a member, the Supreme Moderator with the council acting collegially. Acting collegially, as you know, means that the Supreme Moderator and the council each vote. They each have a vote. And that's the collegial decision. Now, in this next slide, besides those canons that reserve responsibilities to Superior General that we just saw, there are also canons that identify responsibilities to be carried out by what's called the competent major superior, the competent superior, or the competent authority in accord with the constitutions. These provisions are also to be included in your constitutions. Now, this sounds confusing, but just let's follow along, and I think you'll see how this applies to your own situation. Now, these are canons and responsibilities in which the competent, it indicates who is competent to exercise authority, as well as whether advice or consent of the council is required. Now, here we have the constitutional provisions for competent superior or major superior. Now, the canons will say competent superior or major superior, and it's up to your constitutions to say who the competent superior is. Is it the Superior General? Is it the provincial? So that's what these canons are referring to. Suppressing parts of the institute. It is the competent authority, according to your constitutions, with the consent of the council. Financial norms for the institute and alienation of property. Again, competent authority according to your constitutions with the consent of the council. Admission to the novitiate, major superior, according to proper law. Now, this could be the provincial would be a major superior for admission to the novitiate. Admission to temporary profession, competent superior with the vote of the council. Admission to perpetual profession, competent major superior. See the difference here. Major superior and superior, this could be a regional superior. Exclusion from subsequent profession, competent major superior. Change in members' session papers and will, competent superior according to the institute, according to proper law. Apostolate, ministries and missioning, proper superior. Canonical visitation, the superior designated in proper law. And residence, permission to live outside the house of the institute, permission of the major superior, which could be the provincial, with the consent of the council. Now, I know that's a lot, but it's all in the canons. And this is just to give you an overview of the distinctions in who has what authority. Now, some of them, as you saw, mentioned advice and consent, or advice or consent of council members. So just a few comments on this. Council members give advice and consent as required by universal law of the institute's proper law. Consent requires a deliberative vote of the council. The superior cannot act contrary to the vote of the council, but the superior need not act at all. Now, advice is a consultative vote. It is an opinion of the council that must be obtained for validity, but the advice is not binding on the superior. Now, let's see which canons require this. The next two slides list the actions by competent superiors for which the universal law, the canon law, requires consent of the council. That means a deliberative vote that the superior cannot act against. There are several, so I'm going to again go through these quickly. The superior with the consent of the council for dismissal. Valid alienation and other acts of administration in which the patrimonial condition of the juridic person can worsen. The erection, transfer, and suppression of a novitiate house. Permit a candidate to make novitiate in a house other than the designated novitiate house. A lengthy absence of a member from a house of the institute. Transfer of a perpetually professed member from one institute to another requires permission of the supreme moderator of each institute with the consent of their respective councils, and an indult of exclaustration. But you can see in some it's the supreme moderator, competent superior, or superior. The next slide continues. A petition to have exclaustration imposed on a member, that requires the consent of the council. An indult of departure for a member in temporary profession. Readmit without burden of repeating the novitiate, one who has legitimately left after the novitiate or profession. Readmit to an autonomous monastery without burden of repeating the novitiate, one who had legitimately left after the novitiate or profession. Dismissal of a member with consent of the council. And in a grave external scandal or a most grave imminent harm to the institute, the local superior, with consent of the council, can expel a member from the house. And finally, a major superior, with regard to transmitting acts to the supreme moderator for dismissal if the second warning to a member is not heeded. So you see, there are many different ways in which this authority is exercised by different levels of authority, as well as different opportunities and requirements for advice and consent by the council. Now, this slide has to do with the collegial vote. And this is kind of important to look at, especially if we have a small council, a lower number of members on our council. The supreme moderator, in order to issue a decree of dismissal, acts with the council, which must consist of at least 4 members for validity, is to proceed collegially to the accurate consideration of the proofs, arguments, and defenses, and decided through a secret ballot. Then the supreme moderator is to issue the decree of dismissal. This collegial vote is one in which the supreme moderator votes with the council. That is, she has a single vote. Now, if the council is not composed of 4 members, meaning the supreme moderator and 4 councilors, proper law should determine how to obtain 4 council members for cases of dismissal. This could be by naming perhaps former major superiors, for example, or former different superiors who had served as superiors earlier in their lives. But you need 4 for this single act. And then in the case of ipso facto dismissal, after the proofs have been collected, the major superior with the council issues a declaration of fact. That is another occasion on which the major superior actually votes. Now I'd like to talk about delegation of canonical authority. We hear a lot about this today, especially in institutes where there is a decreasing number of people who serve in governance. Superiors, all superiors, fulfill their responsibilities and exercise their power according to the norms of universal law and the proper law of the institute. Those responsibilities and functions that are explicitly granted by law to the supreme moderator, generally carried out by the person holding the office of superior general, as we mentioned before, or president. These responsibilities given to competent major superior are carried out by either a superior general, if there are no provinces, a provincial superior, or a regional superior with a council. Responsibilities assigned in the canons to competent authority in the institute may be given to an authority designated in the proper law of the institute. This would mean a member of the institute. Functions, responsibilities not required to be carried out by competent authority of the institute may be assigned to members of the institute, staff, or consultants. And some examples of where consultants have some responsibilities include finance, human relations, property. Now, responsibilities that are explicitly reserved to the supreme moderator are to be carried out by the superior general, general minister, institute president, or the person with the highest authority in the institute. And here's some examples. Exclaustration, receiving former member back into the institute. Transfers, patrimony, the renunciation of patrimony, acquiring a debt, alienation, and any status of members, decisions on membership, for example, dismissal. Major superiors, this has to do with principles of delegation for major superiors. Major superiors govern by reason of an office. They govern either a whole institute, a province, a part of a province, or an autonomous house of a monastery. Only major superiors, that is, supreme moderators, provincials, or vicars, can delegate canonical authority. Superiors other than supreme moderators possess power or authority within the limits of their function as described in proper law. The responsibilities assigned by law in the canons to the competent authority of the institute may be exercised by a superior designated in the proper law to carry out specific functions. For example, missioning members, decisions on certain financial issues, perhaps budgets, housing, healthcare, retirement decisions, and responsibilities not reserved to the supreme moderator. Now, here we have local, area, and regional superiors. Superiors may be elected or appointed according to proper law. Authority that is delegated to local, area, regional superiors should be delineated or spelled out in a letter of appointment. And all superiors are to have a council. Now, the council members may be elected or appointed according to the institute's proper law. Leaders, and I'm using that word leaders, local or area coordinators who act on behalf of a major superior with authority to carry out specific functions, may be appointed or elected according to proper law. Such leaders do not have a council since they do not hold the office of a superior. The scope of their responsibilities should also be delineated in a letter of appointment. Now, this is an important, this next slide is an important notion that is happening in many of our institutes today throughout the world due to the lack of religious who are eligible or able to hold some governance offices. So let's look at this carefully. This has to do with staff and persons who are not members of the institute. So administrative staff who are not members of the institute, who assist and support major superiors in carrying out their administrative responsibilities, finance, human resources, communications, healthcare, property, do so in accord with their respective position descriptions or their letters of appointment. Today, superiors of institutes with fewer members able to carry out administrative functions that were previously held by members of the institute seek assistance from competent, non-vowed individuals in carrying out administrative responsibilities. This sharing of responsibility should be done with respect for the canonical parameters or we might call them the guardrails, as well as institute policies. The canonical notion of authority, described in Canon 18 that we looked at in the beginning, speaks of authority as exercised in a spirit of service, a notion that sustains the life of the institute and enables it to carry out its mission. The exercise of governance acknowledges the just autonomy of institutes, especially in governance, and enables superiors to provide the structures, procedures, and principles necessary to preserve the institute's patrimony at all levels through consultation, member involvement, shared responsibility, and subsidiarity. It is through such principles that the purpose of governance is fulfilled for building a united community in Christ, where Christ is sought and loved above all things, and the mission of Christ is generously accomplished. I'd like to end this section with a quote from Pope Francis. Pope Francis prays for authority that does not consist in commanding and making oneself heard, but in being consistent, being a witness, and for this reason, being companions on the way of the Lord. Now I'd like to move to the second topic. I'll put that slide up and just take a pause for a minute and reorient ourselves to a different topic. Okay, our second topic is absence from a house of the Institute, timeframes, just causes, and permission. We addressed this topic in the October webinar, and there were many questions. So I'm hoping to respond to some of those questions in this session. The canon, paragraph 1, is the canon giving direction for absence from a house of the Institute. And it has 2 paragraphs. The first says, observing common life, religious are to live in their own religious house and are not to be absent from it except with the permission of their superior. If it concerns a lengthy absence, however, the major superior, with the consent of the council and a just cause, can permit a member to live outside a house, the Institute, but not for more than a year, and then except for the purpose of caring for ill health studies or exercising an apostolate in the name of the Institute. Second paragraph, a member who is absent from a religious house illegitimately with the intention of withdrawing from the power of the superiors is to be sought out solicitously by them and is to be helped to return to and persevere in his or her vocation. The first paragraph describes the timeframes, causes, and permissions required for a member to live outside the house of an institute. And the second paragraph describes how to address a member who is illegitimately absent from a religious house. Canon 665 affirms common life as an essential element of religious life and the obligation of religious to reside in a lawfully constituted house of their own institute. Its focus, however, is on the exceptions to the obligation to live the common life. The canon identifies criteria for the conditions under which a member may live apart from the community. The application of the criteria is subject to the charism and proper law of each institute. Since the canon does not indicate otherwise, the norms apply to both perpetually and temporary professed members. Let's look at paragraph 1 requirements. To live in a house of the institute and not be absent from it without permission of the superior. There are 3 types of absence from the house: the brief absence, absence for a just cause, and absences permitted in law. Excuse me. Paragraph 1 requires a member to obtain the permission of the competent superior to be absent from the house. For brief absences, the local superior would normally be the competent superior to authorize such absences. Regarding brief absences, the local superior would normally, the canon is actually be the competent superior, but the canon is silent and leaves to proper law or the competent superior the length of time for a brief absence. In other words, the canon does not describe how long a brief absence is. It could be 3 weeks, it could be 1 month, it could be 6 months, within a year, as well as the canon does not describe the reasons for a brief absence. Paragraph 1 also recognizes 2 situations for what are called extended or prolonged absences. The first lengthy or extended absence may be granted for a just cause and the permission of the major superior with the consent of the council, but for not more than 1 year. The second type of prolonged absence may be granted by the major superior with the consent of the council for reasons permitted in the law. But there's only 3: poor health or health of the member, studies, and exercising the apostolate in the ministry in the name of the institute. All 3 of these absences are identified in paragraph 1 of 665. So let's look more closely at each one. In the first situation, for an extended and lengthy absence, universal law requires the permission of the major superior with the consent of the council and a just cause. The absence is not to be for more than 1 year. Proper law may determine what constitutes an extended, lengthy absence, as well as examples of just causes. Or the decision may be left to the prudential judgment of the competent superior. However, it is possible for proper law to anticipate, actually, it's not possible for proper law to anticipate every situation for which a member may need to be absent for a just cause. Can competent authority make a judgment as to a just cause? And in my opinion, I believe that superior can do this. Flexibility is a value to be considered in responding to requests based on unforeseen circumstances. I think if we look at what's required, the permission of the major superior, consent of the council, just cause can be something that comes up unexpected. It can be something that happens more frequently, but it is for up to a year. That does not mean that it couldn't happen again the next year or the year after, but the time away is for a year. And I'll go into that a little more here in the next slide. The changing demographics and family needs, more frequent requests for absence to care for ill and aging family members, for harvest or work on family land are more frequent these days, especially for seriously ill or aging parents, and where the family cannot carry out all its responsibilities depending on the situation. So some requests, often involving an extended absence from the Institute, or would mean up to a year, or at times extending beyond a year, call for discernment on how best to support the individual member and her family, and the extent to which other arrangements can be made to avoid excessively long absences, if they can be found to meet the needs of families. In some situations, it may be appropriate for the competent superior to mission the member to caring for an ill or aging parent with a review of that permission on a regular basis. This has happened in communities, particularly where care of the elderly is a part of their ministry. And in this case, it would involve a missioning. In some instances, a major superior may consider granting permission for what we might call discontinuous periods of absence, such as a 3-month period, as long as the canonical requirements are respected, where the member might be away for 3 months, back for 6 months, and then away again for 3 months. But just so the canonical requirements are respected. And then, of course, depending on the situation, the needs of the member and the circumstances of the request to live outside the house, exclaustration may be more appropriate. However, exclaustration, as you know, is a juridical separation between the member and the institute, and it may not always be the only option. Some of the other options do not remove the member from the juridical relationship, but the member remains with the same responsibilities to connect periodically with the institute and especially with the superior. Now, let's look at the extended absence number 2, the taxative list of reasons for living apart from the institute beyond a year that are permitted in law. The only reasons for which permission may be granted by their major superior with the consent of the council for an absence that extends beyond a year are for the health of the member, studies, or exercising the apostolate in the name of the institute. The canon does not place time restrictions on the length of time for the 3 reasons for absences permitted in law. The first exception for living outside the house of the institute is the health of a member. The permission for an extended absence for health is a frequently requested exception, which can involve physical or emotional health. Permission the member to live apart from the institute for studies is the second exception listed in paragraph 1. This exception is not an uncommon one and is often granted to members who have been approved for graduate studies. The student members may also be assigned to a house of the institute for periods of living in community when not in studies, such as during school breaks and summers. And the third exception is for exercise of the apostolate in the name of the institute. The phrase "in the name of the institute" is very important because it reflects the identity of the institute as a public juridic person, through which the institute fulfills its mission entrusted to it in the name of the church. In other words, this mission or ministry is not a personal apostolate or a private initiative that the member freely chooses. It should contribute to the mission of the church and be consistent with the nature and purpose of the institute. Permissions, for the exception of exercising the apostolate while living apart from the institute, require discernment and evaluation on the part of the competent major superior. The superior must determine whether the reasons for the exercise of the apostolate override the obligation in canon law to live common life in the house of the institute. Once granted, the permission continues as long as the member exercises the apostolate or until the major superior requires the member to return. When a member is granted permission to live outside a house of the institute, an agreement between the member and the competent superior of the institute regarding the conditions and the expectations of the member's participation in the activities of the institute and her required contact with the superior and members of the institute, as well as other requirements, can be helpful to both the member and the superior. It's important that the member granted this permission maintains communication, contact, and communion regarding the exercise of her rights and obligations. Although issues related to health could require absence for a longer period, absences for studies and the apostolate should not ordinarily extend indefinitely. For members of monasteries of nuns, the limitation, the instruction verbi sponsa, placed on absence from the monastery has been repealed by the instruction cor orans. For a just cause, the major superior, according to the norm of cor orans, and with the consent of her council, may authorize the absence from the monastery of a nun with solemn vows for not more than a year after hearing the diocesan bishop or competent religious ordinary. Now, Canon 665-2, as we saw earlier, states that a member who is absent from a religious house illegitimately, that is without permission, and with the intention of withdrawing from the power of the superiors, is to be sought out solicitously and helped to return and persevere in his or her vocation. Paragraph 2 addresses a member who's absent without permission and intends to withdraw from the authority of the superiors. But the canon does not attempt to describe the reasons for the withdrawal. Rather, it provides a pastoral approach and a strong exhortation to superiors to seek out the member, offer assistance for returning to the institute, and the support needed to persevere in her vocation. Pastoral solicitude is the underlying value of paragraph 2 that guides the efforts to restore the member's relationship to the institute. If the member persists in absence from the institute beyond the authorized time and refuses to return or cannot be located, the competent superior should continue to seek out the illegitimately absent member. After a 6 months illegitimate absence, the superior may initiate a process of dismissal from the institute in accord with the procedures of Canon 697. If the illegitimately absent member cannot be located after at least 12 months, Pope Francis recently, within the last year, authorized a change in the law, Canon 694, paragraph 1, by adding prolonged illegitimate absence from the religious house lasting at least 12 consecutive months as a third reason for ipso facto dismissal from the institute in accord with Canon 694, paragraph 2. In the third paragraph of Canon 694, the canon provides that the statement of the case must be confirmed by the Holy See or by the diocesan bishop of the principal see for institutes of diocesan right. I'd like to end this section with a quote from the congregation from Institutes of Consecrated Life on the document Fraternal Life in Community. It states, religious community is a visible manifestation of the communion, which is the foundation of the church, and at the same time, a prophecy of that unity towards which she tends as her final goal. We'll take a moment before we go to topic 3 on the personal patrimony of members of religious institute. In this section of our webinar, we will consider the canonical norms on personal patrimony and their application for members of religious institutes. I would say just in the beginning, those of you that are participating from your monasteries, some of this in the beginning does not apply to you, but when we get to renunciation at the end of this section, hopefully they will be part of your proper law. So what is the spirit of canon law governing property or assets belonging to members of religious institutes? Canon 600 provides a perspective on the spirit of the law. The canon describes the vow of poverty, stating the evangelical counsel of poverty in imitation of Christ, who, although he was rich, was made poor for us, entails, besides a life that is poor, a life in fact and in spirit, and is to be led productively in moderation and foreign to earthly riches, a dependence and limitation in the use and disposition of goods according to the norm of proper law of each institute. It is the last two elements of the canon that relate directly to the personal property of members of religious institute. That is, that the vow of poverty requires dependence and limitation in the use and disposition of goods according to the norms of the proper law of each institute. So what is personal patrimony? Well, the first thing is canon law does not provide a definition of personal patrimony, but it is generally defined as the real and personal property that one possesses at the time of first profession in the institute and what a member inherits after first profession from family members. The proper law of each institute or society should indicate whether a vowed member, according to the nature of the institute, may retain ownership of personal assets, and if so, define the property over which a vowed member may retain ownership. Canon 668 is an important canon and a complex one governing the legal, meaning both the canonical and civil aspects of personal patrimony belonging to members of religious institutes. It is found in the chapter of the Code on obligations and rights of members and institutes. It regulates the relationship of the vow of poverty to the dependent use of material or temporal goods. And each institute is to determine in its proper law the values underlying the practicalities of Canon 668 in accord with the nature, spirit, and character of the institute. So let's look at the first 3 paragraphs of Canon 668, and then we'll look at paragraphs 4 and 5 separately. Before first profession, members are to cede the administration of their goods to whomever they prefer, and unless the Constitution state otherwise, are to make disposition freely for their use and revenue. Moreover, at least before perpetual profession, they are to make a will which is to be valid at civil law. Second paragraph, to change dispositions for a just cause and to place any act regarding temporal goods, they need the permission of the superior competent according to the norm of proper law. And thirdly, whatever religious acquires through personal effort or by reason of the institute, the religious acquires for the institute. Whatever accrues to the religious in any way by reason of pension, insurance, subsidy, stipend, is acquired for the institute unless proper law states otherwise. Paragraph 1 of Canon 668 regulates the relationship of an individual religious to personal property according to the constitutions. It obliges the novice who owns any property before first profession to cede the administration of her property, personal property, to another, to dispose of or make provision for the use and revenue from any property, and prior to perpetual profession, to draw up a last will that is legal at the civil law of the jurisdiction. So let's look at first, what is an act of cession? In carrying out the first requirement of paragraph 1, the novice may select whomever she chooses, a friend, a relative, a lawyer, a bank, the religious institute, or other party, and unless the Constitution state otherwise, transfer to that person or the institute the responsibility for the administration and oversight of the property. There are no specific canonical requirements for the selection of an administrator who is outside the institute for a member's patrimony. However, the person, the law firm, the organization that is selected should be knowledgeable about canonical regulations governing personal patrimony, such as the unavailability of the assets for the personal use of the member and submission of an annual report to the member and the institute leadership on the activity of the assets. The person who accepts the responsibility of acting as administrator assumes a fiduciary duty to preserve the assets in accord with what is in the best interest of the member. So, what are the effects of the act of cession? The effect of the act of cession is that the professed member relinquishes control of personal assets while maintaining legal ownership of the assets. The novice may give the administrator instructions or directions regarding the use and disposition of the revenues that the property may produce, except directing the revenue to herself as regular personal income. If the constitutions of your institute state a contrary custom, such as requiring the interest earned on goods when administered by the religious institute to revert to the institute, this provision and its meaning should be clearly indicated to the novice. But if a contrary custom is not provided in proper law, the freedom of the disposition by the novice would stand. What is clear in paragraph 1 is that the property does not cease to be the personal property of the individual religious unless it is prohibited by proper law. Although the vowed member retains ownership of her assets, personal patrimony is not to be used by the member for personal use, such as trips, vacations, etc. The third provision, the last will, made prior to perpetual profession, is not required at the time of temporary profession, though some institutes do require its execution, especially if the member has significant assets. The canon adds that the will should also be valid at the civil law of the jurisdiction. Some members, as you probably know, may already have a will prior to entrance, and if so, this could remain unless there is a reason to modify it prior to perpetual profession. The religious is free to dispose of personal property in the will as she chooses. The institute cannot require that a member name the institute as the sole beneficiary of the will. Now let's look at paragraph 2 on the notion of dependence. The second paragraph of Canon 668 reflects the notion of dependence, stating that for a just cause, a religious must obtain the permission of the competent superior to change the cession papers or the last will and testament. Paragraph 2 identifies 2 conditions required to change the cession of administration, as well as a member's will, namely a just cause and permission of the competent superior according to proper law. A just cause for a change in the documents, such as a family situation, a need to change the administrator, a change in the value of the assets, or new needs to which the religious wishes to contribute may suffice as just causes. But a just cause should be broadly interpreted to include reasonable requests. Permission to change the documents generally should not be denied for a just cause. So what are the requirements of paragraph 3 regarding dependence? Paragraph 3 states that whatever a religious acquires through personal work or by reason of membership in the religious institute is acquired for the institute. And unless proper law states otherwise, those things which accrue to the religious by way of pension, subsidy, or insurance in any way whatsoever are acquired for the institute. So what does this mean? Paragraph 3 is a very important paragraph in this canon. It further details the notion of dependence and addresses the responsibilities of the member toward the religious institute. It pertains to the relationship between the religious and the institute in virtue of profession through which the religious has been incorporated into the institute, and the obligation of the institute to provide whatever the member needs to carry out her vocation. Paragraph 3 describes what is not the personal property of a member. It applies to that which a member receives after profession because of her work or ministry as a religious or on behalf of the institute. And this would include stipends, salaries, royalties, honoraria, pensions generally after profession, benefits, subsidies, or insurance, unless proper law states otherwise. The canon does not address questions of pensions or benefits that a member receives from employment prior to profession in the institute. Today, women and men enter religious life after work experience, often have a retirement or pension plan earned prior to entrance and profession. Your proper law should address this question and determine whether such benefits are considered the personal property of the religious, or in some institutes as income to the institute. Policies regarding benefits earned by members prior to entrance into the institute will vary from institute to institute. And it is important to consider the civil law provisions pertaining to some pensions, which should be taken into consideration for institute policies. Now, paragraphs 4 and 5 address questions related to renunciation of personal property in whole or in part. Paragraph 4 states that a member, who must renounce fully his or her goods due to the nature of the institute, is to make that renunciation before perpetual profession in a valid form as far as possible, even in civil law. It is to take effect from the day of profession. A perpetually professed religious who wishes to renounce his or her goods, either partially or totally, according to the norm of proper law, and with the permission of the supreme moderator, is to do so. And paragraph 5, a professed religious who has renounced his or her goods fully due to the nature of the institute loses the capacity of acquiring and possessing, and therefore invalidly places acts contrary to the vow of poverty. Moreover, whatever accrues to the professed after renunciation belongs to the institute according to the norm of law. So let's look at each paragraph separately. Paragraph 4, renunciation of ownership. Like some of the other canons we've looked at today, this one paragraph has two items in it that we have to look at. Paragraph 4 addresses renunciation of ownership of one's personal property in two ways. The first part of paragraph 4 applies to religious institutes with a tradition of solemn vows. That is what is referenced by the nature of the institute. The canon requires renunciation of all personal property, and when possible, this act should be carried out according to civil law and takes effect at solemn profession. The second part of the same paragraph refers to religious institutes, members of religious institutes, with a simple vow tradition where members may retain ownership and the right to acquire property. If proper law permits this, the perpetually professed religious, according to the nature of the institute and its constitutions, may renounce a part or all of her patrimony in accord with proper law and with the permission of the superior general or the highest religious superior. Proper law can set conditions for renunciation. For example, it can require a member be professed for a certain number of years prior to making such an act of renunciation. This would be in institutes with simple vows, and many institutes require the member to be perpetually professed for 10 years before making a total renunciation of personal assets. And again, the civil law provisions pertaining to renunciations should be taken into consideration. So let's look at what the consequences of renunciation are in paragraph 5. These concern paragraph 5 concerns the consequences or the effects of renunciation at the time of solemn profession in accord with the Institute's constitutions. A religious loses capacity to acquire or possess goods. The religious places acts contrary to the vow of poverty, such as purchasing a car or a home. And whatever accrues to the religious after solemn profession belongs to the institute according to proper law. It is important to clarify the provisions of Canon 668 that apply to your institutes and to ensure that the members know and understand them. Many of the problems facing religious superiors today concern the use of money, and members' awareness and understanding of the requirements of the vow of poverty regarding assets and property issues. Again, let us end this section with a quote from Pope Francis on the vow of poverty that he gave in 2015 in Havana, Cuba. He said, when religious take a vow of poverty, they are not espousing poverty as a good thing in and of itself. Instead, their path of poverty is intended to lead them to what mystics of all stripe call inner detachment. A vow of poverty skews material possessions in order to cultivate a higher love. It frees a consecrated person from material things so that he or she may be properly attached to all things. Our next topic is diocesan bishops and religious superiors, authority and relationship. We'll begin that in a moment. The 1979 instruction on the joint directives of mutual relations between bishops and religious, mutuae relationes, promulgated by the Congregations for Bishops and then Religious and Secular Institutes, was developed as a practical means to ensure an orderly and fruitful cooperation and collaboration between bishops and religious at all levels. Though the functions and responsibilities of bishops and religious appeared to be clear theoretically, there was at that time, and there still is today, no single model to describe the relationship between bishops and religious. The instructions, mutuae relationes, affirms the conciliar teaching that the unity of the church depends ultimately on the presence of the Spirit, that the Spirit is the source of the diversity of relationships within the church, and that no individual possesses all the gifts given for the building up of the body of Christ. Mutuae relationes makes clear that no one can exercise any function in the church except in communion with the bishops. Regarding religious, mutuae relationes affirms religious life as a special gift for the entire church, that religious institutes exist for the church, and describes the charism of the founders as an experience of the Spirit passed on to their followers to be lived, guarded, safeguarded, deepened, and constantly developed by them. The instruction also refers to the distinctive character of each institute and places fidelity to the charisms as first responsibility of religious. A new instruction, reported to be prepared by a Vatican commission made up of officials from the Congregation for Bishops and the Congregation for Institutes of Consecrated Life and Societies of Apostolic Life, with input from a worldwide consultation with superiors and of Women's and Men's Institute, was reported over the last few years. The commission also received input, according to news reports, from the Congregations for the Doctrine of the Faith, Pontifical Council for Legislative Texts, and the Secretary for State. But currently there is no further public information on the status of the document. Though we do not know the content or status of the new directory, we know that Pope Francis has expressed the importance of coessentiality between the hierarchical gifts of the bishop and the charismatic gifts of the consecrated person. This notion is also reflected in the 2018 document of the International Theological Commission, Synodality in the Life of the Church, when it refers to synodality as the modus vivendi et operandi of the church people of God, and that concretely synodality manifests and realizes its communion in walking together in mission. In Joy of the Gospel, Francis speaks about charism and communion, stating that a sure sign of the authenticity of a charism is its character, its ability to be integrated harmoniously into the life of God's holy people and faithful, holy and faithful people for the good of all. Francis adds that it is in communion, even when this proves painful, that a charism is seen to be authentic and mysteriously fruitful. In this context, a new instruction might address situations in which, for example, a religious institute is present in a diocese, but with no connection to the life of the local church or its ministry. And on the other hand, situations in which a religious institute is recognized only for the functional aspects of the services it provides the local church. Though we do not have information on when or even if a new instruction will be promulgated, Francis has identified one of the Synod commissions to address the relationship between bishops and consecrated life. Perhaps the work of the new commission, the new Synod commission, will provide guidance for the mutual relations between bishops and religious in promoting ecclesial communion in the life of the church some 45 years after Mutuae Relationes. Let's look at the roles of the bishop and religious in the context of canon law. One of the more significant characteristics of the revised code of canon law is the enhanced role of the diocesan bishop. The diocese is entrusted to the pastoral care of the bishop. He presides over it with sacred power as teacher of doctrine, priest of sacred worship, and minister of governance. And he is the foundation and principle of unity for his particular church, a pastor to the people entrusted to his care. The diocesan bishop has all the power necessary to carry out his pastoral ministry and to exercise his pastoral leadership, except for cases in which the law or a decree of the Supreme Pontiff reserves to the supreme authority or to another ecclesiastical authority. Episcopal power is distinguished by its divine power, divine origin, and by its context of ecclesial communion. His power is ordinary, that means attached to his office, proper, that is entrusted in his own name, and immediate, or exercised directly over all the faithful of the diocese without the need of an intermediary. The diocesan bishop administers the diocese in his own name, not as a representative of the Holy Father, but as a vicar or delegate of Christ. Since the bishop's power can be regulated by the Pope and restricted in certain aspects, such as by requirements for consultation and consent in administrative matters, his power is not absolute. In virtue of his power, bishops have the right and duty to issue laws for the faithful, to make judgments, and to regulate everything pertaining to the good order of worship and the apostolate. There is an interconnection of the teaching, sanctifying, and governance functions that focus the entire ministry of the bishop on serving God and the Christian faithful. Within the councils, the church's conciliar and post-conciliar teaching and the revised code, a principal service of the bishop is to ensure the good order of the apostolate throughout the diocese. This is an area in which religious and their apostolic works relate most directly to the diocesan bishop for the pastoral welfare of the people of God. Canon 394 calls on the diocesan bishop to promote various forms of the apostolate in the diocese and to coordinate all apostolic works throughout his diocese. The code also addresses the authority of the bishop regarding apostolates, either proper to or entrusted to religious institutes. Canon 678 reflects the dual authority to which religious are subject in performing the works of the apostolate. Religious are subject to the religious superior for the life and mission of the institute, and to the diocesan bishop for the apostolate. Religious are subject to the diocesan bishop in all that pertains to the care of souls, that is parish and campus ministry, to public worship, and all other works of the apostolate. Additionally, Canon 681, paragraph 1, calls for written agreements between bishops and the religious superior for works entrusted to religious institutes, such as parishes, schools, and other ministries of the diocese. The code recognizes the need for cooperation and dialogue between diocesan bishops and religious superiors to achieve a balance between the role of the bishop as pastor of the local church and the rightful autonomy of the religious institute. Canon 678, paragraph 3 is particularly relevant. It is a very strong exhortation for bishops and superiors to proceed through mutual consultation in organizing the apostolate and suggests that meaningful consultation will happen only if mutual trust and honesty characterize the dialogue and collaboration that take place between bishops and superiors. However, the knowledge and observance of laws alone will not guarantee that bishops and religious express communio that characterize the church. Rather, the mission that is entrusted to both bishops and religious requires that they establish a sincere relationship of collaboration through an effective and open dialogue. It is not hard to see that consultation, coordination, and cooperation among major superiors, leaders of religious works, and the diocesan bishop are essential for the sake and mission of the local church. In practice, this means, for example, that a religious institute does not decide to close or to end its sponsorship of a school, a college, or other apostolic work without communication and consultation with the diocesan bishop. It means that the diocesan bishop exercises oversight responsibility for the teaching of faith and morals in the apostolic works of religious institutes. It also means that the diocesan bishop should involve the leadership of religious institutes and their apostolic works in the pastoral planning of the diocese, including membership in consultative structures in the diocese. In other words, the more open the channels of communication and coordination are between the major superiors and leaders of apostolates that are sponsored by religious and the bishop, the more effective will be the missionary dynamism in the diocese. The task of coordination is directed toward achieving good order to safeguard the unity of the diocese. Practically speaking, such coordination usually requires the development of channels of structures of communication and collaboration to facilitate and encourage a healthy exchange of information and experience. Coordination of apostolic works on the part of the diocesan bishop and major superiors requires recognition of the rights and duties of the faithful in building up the body of Christ. But even with the best intentions, on occasion communication breaks down, trust is jeopardized, or cooperation is threatened. And there is no template for how best to resolve differences. But initiating communication and opportunities for interaction with the diocesan bishop are important ways for developing and nurturing a positive relationship based on trust, cooperation, and dialogue that recognizes the respective roles of the religious superior, the apostolic leaders, the apostolic work leaders, and the diocesan bishop. I pushed this too far, sorry. A relationship of trust requires openness of mutual and respectful dialogue, and the dialogue of walking together in a synodal way and communication are essential for unity and communion between religious superiors and the local church. Excuse me, but somebody keeps requesting control of the screen. Am I supposed to approve this, Paula? I can't move up.
No, Sharon, so just ignore, just go back to your PowerPoint and
I'm
you
sorry.
can have a, yeah, that's right. Sometimes that happens.
Thank you. We know that the strength of the church is found in communion, that is union with, which is the real source for witnessing the relationship among the disciples of Jesus Christ. The Church's teaching and its canonical notions can favor a harmonious and fruitful collaboration among major superiors and bishops. But not all problems presented by life are resolved by the application of canonical norms. Canon law is nonetheless a servant of communion. The search for the common good, love, and a genuine desire, together with a strong sense of communion and an application for creative dialogue, will always provide the best help. In an address to the general chapter of the Oblates of Mary Immaculate, Pope Francis spoke of the challenge of communion today. He said, communion today is a challenge on which the future of our world, the Church, and consecrated life may depend. To be missionaries of communion, it is necessary, first of all, to live it among ourselves, in our communities, and in mutual relations, and then to cultivate it with one another without exception. These are indeed times of challenge and opportunity. The concluding words of Mutuae Relationes emphasize that a real efficacious thrust of dialogue and collaboration happens only when the bishops and major superiors are deeply convinced of the necessity and the nature and importance of such cooperation, of mutual trust and respect for the role of each individual, of mutual consultation in determining and organizing undertakings at every level. Perhaps then will we know more fully the experience of the Church's communion. Thank you.
Sharon, thank you so much. I suggest that we can stop as well for a minute or two to now let these last part of the presentation to sink in. And I have gathered some of the questions that were present in the chat. So we'll look at those in a minute and then we continue. Thank you. Okay, many questions keep coming up. Let's see, what can we do? There's so many realities behind the law. There's so many realities. Life is much bigger than the law. I'm going to try to follow the order of your presentation, Sharon. And the first question that the sisters have asked, and I think it's an easy answer, but I will give it to you. What is the difference between supreme moderator, major superior, general superior? So this names that the canon law gives. What can you specify? What are the differences, please?
The supreme moderator is the highest authority in the institute. Now, you may, most likely, you do not call that person the supreme moderator. Some of the examples are superior general, general prioress, or prioress general, but it's going to president, though it's the highest person in the institute. And sometimes the institute does not have provinces. So those institutes that are what I would call self-standing institutes. The highest authority in that institute is, in the canons, referred to as a supreme moderator. A major superior is likely to be the provincial of a province, or even possibly a region. Depends on how your institute has structured your regions. But it's a high authority, but it is not the highest. So if you have if you are the highest in your institute, then you are the supreme moderator. If you're a major superior, I would have to say sometimes in institutes that are self-standing, they would call them the president or the superior general. You might call them a major superior. They are a major superior in the sense they can make the same decisions a major superior, but they also have additional authority than a major superior would.
Thank you. Thank you very much. Another question, it's on the general councils. So if a general councillor has the delegation to, receive the delegation to perform a canonical visit, how does that work?
A general council member could be given that delegation as part of her office. It should be in writing. And it's not, see, with the general council, you've got the supreme moderator, and the vicar is a major superior as well. The council members may or may not, probably not major superiors, but they can be delegated on behalf of the superior general to carry out some of her functions. But I would just suggest putting them in writing, unless it's in your constitutions. In other words, that the visitations may be conducted by a general council member.
And does have a supreme moderator has the duty to visit all the communities in her congregation during the mandate?
It depends on what your proper law says. Now, that might not be possible in some institutes. I know it is not. So it would depend on what's in your proper law. That the general it might say that the superior general has the responsibility to visit, but can also, and then that in the Constitution, in the proper law, that she can delegate a general council member to do that, or even to serve as a liaison, depending on how widespread throughout the world the institute might be.
Thank you. I'm going to pass on to the second topic about absence and exclustration. And I think it's the question we had last time. Is taking care of an old and sick parent included in the just cause for a lengthy absence? You spoke about sometimes in some congregations being sent on mission to do that, but generally that's one of the causes that sisters are outside of their community houses. So how to deal with that?
One of the things that I think is important to consider, it is something that can be considered a just cause. So that that first provision for a just cause, now you know that can't be for more than a year, but it can be for 3 months, it can be for 6 months, but it's a just cause that a local superior or a provincial could make. The value of that, rather than exclustration, is that the person retains the juridical relationship to the institute. Exclustration, they remain a member, but they're also separated. And they have to honor the vows, but only according to their condition. In other words, they might have to get a job to help take care of their parents under exclustration. But the just cause, what I think can also happen is if there are siblings, we see people taking turns. The sister might go for 3 months or 4 months. Another sibling might go for another period of time, and then the sister might go back later. Those kinds of things happen. I think it's important to see what the need of the family is, and also who the sister is, how connected, how much does she, I'm trying to find the right words, want to remain a member of the community and active in the community while she's taking care of her parents. In other words, to continue to participate as much as she can in the community's life, not living with them because she's taking care of her parents. It's a judgment. It ends up being a judgment on the part of the superiors.
And you're saying that it's up to a year. And if it's longer than that year, looking after the parents for any case, does the sister, sorry, go ahead.
I think you'd have to consider the need. And it might have to be exclustration if it's going to be for multiple years. Or it could be she would come home for 6 months while somebody else takes care, and then she might go back for another period of time. It's just that the stretch of time cannot be over a year. And you know, we're trying not to be look at the minutiae, but to look at both the needs of the individual sister who may need to come back to community to be nourished again. And that's the kind of judgment that the superior needs to make. But on the just cause, definitely maintain contact. Definitely.
Depends very much on the relationship and the person.
Yes, exactly.
A sister just reminded us that the exclustration now has been extended from 3 to 5 years. Can you just underline that, please?
Yes, it has. Pope Francis extended it from 3 to 5 years. And if you want it longer than 5, then you have to get Rome's permission. I think it's an interesting change. I don't know if some of the experience in the dicastery was many requests for extensions. And that perhaps that's the reason. It seems to me 5 years is a long time to be apart from the community.
It is indeed. There's a very interesting question. If the sister is living on an intercongregational community, as there are many, does she have to have a special permission, because the house in itself doesn't belong to that congregation, probably belongs to another institution?
No, I think just making sure that her staying there, her missioning there, is in writing, because many communities are part of intercongregational novitiates, and that's not a house of the Institute either, but it's designated as as intercongregational. I think you just need to note it and make sure that there is some kind of agreement with the member on how much contact she has with the community of which she is a member.
Okay, so that will be under the missioning the name of the institute, as you said before. Yeah?
Yes.
Okay. So moving on to another topic, how to deal with members of the institute who withhold their pensions and refuse to hand them over. So what happens if the salary is kept? What happens if the person doesn't want to give it back to the community?
Well, I would just tell you that 2 years ago, I worked with the community on a dismissal for that.
Okay.
Because she refused to give her compensation for several years, and even through the 2 warnings, did not give any of it in. Pensions might be different based on, at least in the United States, the person receiving a pension, the name cannot be changed legally, who gets it, until the distribution of the pension takes place. So that has to be worked out. What's happening in many cases here is the pension is going into a fund at the institute level, but it remains in the member's name, no access to it. But until she can distribute it legally, it remains in her name. That might be true in other countries, but whatever the civil law around pension, or I think in some places it might be called subsidies, those things need to be taken into consideration. But the main point is that she not have access to it. That's the main point, to spend it.
Okay. And you spoke about the duty of the person to hand over the money. What is the duty of the congregation to look after the sister or the sisters?
The duty of the congregation is to provide everything the sister needs to live out her vocation. It's Canon 670. It doesn't specify. It's all she needs. Now, each congregation and the needs are going to be different. The needs are going to be different for a monastic nun, and then they are for an apostolic religion. The needs are going to be different across cultures and across countries. But certainly living, healthcare, whatever are the necessities, retreats, all those kinds of things, so that the personal assets that are part of patrimony are not to be used for that. They're basically not used until the sister renounces either in part or all. And if she doesn't renounce them and they're part of her will, then it's not distributed until she dies. But that's not, in other words, whatever she has as assets shouldn't be paying for her education. That's the community's, you see what I'm saying? So that the idea of dependence is on the community, and the distancing from any of those assets in communities where they're allowed to retain ownership is really at a distance.
And you're saying that it only would be distributed when she dies, not whilst she's alive.
Well, she can, depending on the community. Like often, some communities allow sisters with patrimony to distribute it to their families as needed. Some provide and use that, give it to their families for the education of nieces and nephews. So they get rid of it. I mean, the idea is to get rid of it, either in life or at the time that you die, but just get rid of it. And especially when religious reach the age of between 60 and 70, we tried to encourage all members to renounce it because they don't need it. But we can't force them to do that if the proper law allows them to retain it. You can see how critical proper law is in all this.
You said something as well, the institute cannot require to be the sole beneficiary. Can you explain that a little bit?
The institute, the will is something that a person makes out before first profession. And I don't know about today, but when many of us entered, we didn't even have anything. So the will was whatever I get goes to the community or whatever. But certainly an institute cannot say that what you have inherited from your family must go to the institute. That's what they can't say. Now, if an institute wants to do that, it has to be well known way before at the time a person certainly enters in a bishop.
Okay.
But it doesn't belong to the institute. She should be freely giving it.
She should be free to decide. Okay, passing on to the last topic on the bishops. When a congregation decides to close a work, a school, a hospital, can the congregation do so? Does it need to consult? Does it need to inform? How does it go?
I believe, in my experience with bishops, and your schools, your apostolates, the ones that you sponsor and have funded and have operated for generations, are also an apostolic work in his diocese, over which he has some oversight. And simply informing him that you are going through an assessment to determine whether you can continue the ministry or not is more of a courtesy than anything else. And once you've made a decision, you should let him know, because it has been part of his oversight and the apostolic works of his diocese. If you announce to your people, to a school, you're closing, and it's in a newspaper, and he's the last one to read it, that is it's kind of like you're hearing something from one of your houses that you should have heard before they've taken action. He doesn't have to give permission. He doesn't even have to give a votum unless you are alienating it. But it's a courtesy in terms of a relationship from one authority to another authority. As head of the religious institute, as head of the diocese, we are moving or closing an apostolic work in your diocese. It enables a dialogue to take place. It shows some kind of a mutual understanding of the roles, and it's information. It's part of the ecclesial communion, because that school has been part of the communion of that ecclesial communion of the diocese.
Thank you. There's a question on the topic you've mentioned about administrative staff that are no members. So is it possible for a non-member to be a provincial treasurer?
Yes. Now, this is very interesting because the Canon 639 says that each institute is to have a financial officer who reports to the major superior or the superior general, major superior, I think, and with an annual report on the budget. The canon does not require a member to be the financial officer. Constitutions often do. And that's where there's been some constitutions who have changed and just indicated that the superior will appoint a financial officer. Could be a member of the institute, could be a layperson. But what we're seeing is in this country and in others, the complexity of the financial issues that religious are facing today really requires a level of competence that many communities do not have in its members any longer. And therefore, hire a professional who acts as a CFO or a finance director or finance officer, accountable. That person must be accountable to the superior, the major superior, whether it's a province or an institute, whoever is the authority, and could also be accountable to an institute treasurer. But it might be in name only, because the work is going to be done by the layperson. And that's if you still retain in your constitution that there is a general treasurer or a provincial treasurer who is part of the council. This layperson would not be part of the council, but would report to them what's happening. Does that make sense?
It does inform, it does give the reports, but doesn't have the vote in the council, doesn't have the authority to take decisions. I think
it does the financial work and reports it to, and is accountable to.
There are several questions as well on the absence from community, in the sense, modern absence, that the person is not traceable, that has disappeared. So what to do if the superior tries to reach out, there's no contact? I think the canon law is very clear, but it's difficult decisions to make, I suppose.
They are very difficult decisions. And I think the best thing is to keep reaching out and document it. If you have sent mail by postal and it's returned, keep it. If you've tried to locate by email, there's no response. Whatever you've done, keep a record of what you've done and when you've done it. And if you're unable to reach the person, after 6 months, you can initiate the dismissal process. And if there's still no answer, and that would be the warning, first warning and second warning. And if after 12 months there is no response, then it's an ipso facto dismissal, which in Canon 694 does spell it out now in the third paragraph, what you have to collect. And that's why you have to keep a record of all this. And then you send it to Rome for confirmation. You and your council declare it an ipso facto dismissal with all of the data you have, and then you send it to Rome for confirmation.
Just not to end on this last question, which is a sad one. We are just on time. Regarding canon law in general, I think it's something that it's very important. As you said, canon law serves communion. What would be the advice, the comment you would leave at the end? Because I'm aware that for severe generals, for general councils, for provincials, for the sisters who listen to us, sometimes seems a very difficult world. Sometimes it's something that they're acquainted to. When these situations, all the situations come to happen, what would be the advice, canon law wise, that you would give all of us, please?
Well, I think canon law is supposed to help you, not control you. And I think if you see it as actually what it's trying to do is protect everyone's rights, your rights and the rights of your members. And it's flexible. It's flexible. And you have to take into consideration your own circumstances and your proper law. Your constitutions should include what has to be in there according to canon law. But how those things are handled in proper law is your own within those parameters. But I think if you saw it as it's a servant of communion, it should help you maintain the communion with your members, with the church, and with God. It's ecclesial communion at its most. And I think that's why Francis, I don't know because I don't know Francis, but the fact that there is a commission to address the relationship between bishops and superiors suggests that he sees it as something together, not apart. And that's the same with the other issues that we've talked about. With patrimony, with absence, there are occasions for absence and there are occasions when you have to be there. Those are the things that we just have to keep in mind is what are the needs we're trying to meet and what's the best way to meet them in keeping with our mission and our proper law.
Sharon, thank you. Thank you so much. I think, and I've seen some comments that has been a lot, but that's life. I do invite the sisters to reread. I will send soon the PowerPoint. I think it's a question of rereading again. Whenever the registration is edited, I will send it also so that we can listen.
It's a lot. It is a lot of information.
It is a lot. It's a huge lesson. It's like we were back at school, which is good to relearn these things, which I already knew many of those, but it's always good. And now actually things are
Paula, can I
changing.
just say something to you about this? I find that leaders, especially new superiors and ones that are coming back into office, that they're understanding we really need to do more orientation with leaders on canon law. And I really commend UISG for this. I just want to say that we have 500 communities that are members of our organization, and canon law and civil law now, but canon law is a significant need on the part of leaders, just because you're so involved in the day-to-day leadership responsibilities that we just need to be on top of things to help you, give you the resources you need to help you with the decisions you have to make. So I'm grateful to be part of this, really.
Thank you, Sharon. Yeah, we'll continue to count on you. I will send as well the website of RECRE to the sisters so that they can reach out.
And the toolbox is open to all of them.
Okay.
The toolbox on the website. And I'll just tell you this, the password is UISG. And excuse me, the username is UISG. And the password is toolbox 2015, capital T and all one word, 2015.
2015.
That's when we put it up.
I will share that with the sisters as well. And also we want to continue providing consultation on canon law. So please keep in touch and we will inform you, because it's really something that we need to learn. And actually, as the general councils and superiors change, formation needs to be in place. I really encourage all of us, all of you, to read your proper law, because it's so important. Sometimes we have answers for many things, for many questions, and we don't know it. So I think it's very important. And I would like to underline what Sharon, you said. It's about love, it's about flexibility, it's about communion and reaching out to people's needs. And all of these needs to be together. And canon law teaches us how to love when we don't know how to do so. So sisters, thank you so much. We will soon be in touch. I will send you via email all the presentations translated. And as I said before, when the registrations are ready, again, I will make them available to all of you. And thank you so much. Thank you so much for making the time to be with us. And I really invite you to open the microphones and to say goodbye to each other, and to thank Sharon for this amazing lesson and opener to the canon law reality.
Grazie, Sharon, ci
Sì, grazie mille, buon lavoro, buona continuazione, fatemi anche. Grazie, ciao.
Gracias.
Thank you.
Merci, merci à toutes.
Thank you.